Ask Mr. Khonikot to be here. If he doesn't appear, sometime we'll pass the order. Three.
Yes, sir, Worship. Worship, kindly pass over the matter for a time.
Yes, Mr. Das. Whether the service of the petitioner can be provincialized as a principal.
As per affidavit, my lord, he is not qualified, my lord, for the post of principal.
What is the illegality or what's the petitioner doesn't have what kind of eligibility as required for the post of principal?
My lord, in our affidavit, para 4, my lord, he doesn't have 15 years, 15 years of teaching experience, my lord. While joining as a principal at franchise schools, my lord.
Now, Mr. Das just tell us one thing. When this 2010 regulation of the UGC came into force, yes, Mr. Takwilder, any idea when this 2010 regulation came into force?
May 2010. My lord, June 2010, my lord.
Whether it has to be adopted or not. When did you adopt?
My lord, 2010 hadn't been adopted.
When it was issued? Just think, if you cannot assist the court, it is difficult for the court to adjudicate the matters, that every time court has to of its own find out all things.
Well, actually, Mr. K. Gogoi is looking after the matter, my lord.
That cannot be a thing, Mr. Das. You are supposed to know, you are representing the higher education.
Yes, my lord.
You must have the regulations of you. You must know when these things have been given effect in the state of Assam. It gives a different impression altogether, consistently telling you, and if you don't understand what to do. Unless you have all these informations with you, how will you do? বৰুৱা, নেট নাহিলে কাম কেনেকৈ কৰিব? কিবা এটা বিচাৰিব গ'লেও নেটত নাহে। কাউন্সিলে একো ক'ব নোৱাৰে। What is this? Tabot চালু নাই, তাতে চালে নাই। If the net is not coming, how you find out? তুমি নালাগে, নেটত কিছু নেই, নেট নহ'লে বিচাৰে দিগদাৰ হৈ যায়।
বছৰ এইটো হয়, অসমে কেতিয়া ল'লে আমাৰ খেলত পৰিব? জুনত গেজেটত আহিছিলে, কিন্তু 2010 জুনত গেজেটত ওলাইছিলে। আমাৰ আসামে কেতিয়া এডপ্ট কৰিলে?
Yes, ma'am.
She, sir, here Guya is on like another court. Final pass over the matter for a time.
My lord, matter may be taken up in another day, my lord. Mr. K. Gogoi is not there.
Matter number
Next.
4 and 5.
Yes, is your lordship.
Lord, I seek adjournment for the day conducting council is not present in audit.
Who is representing?
SP Sharma or APDCL.
Lordship, in one of the last two orders,
On 14th. No further adjournment will be granted as the idea of the parties. Inform.
Obliged. 6. Kindly see the last order.
Yes, lawsuit, I have seen the last order lawsuit directed that affidavit from the secretary and director is to file lawsuit. Only yesterday lawsuit I have received the instruction from the director. But that was lawsuit I have to, I have again wrote to the director to clarify on some points lawsuit. Okay, lawsuit, but I have seen the inspector has filed one affidavit. My up-to-date instruction is that there is no record found in the office of the inspector of school regarding the appointment of the petitioner on leave, lawsuit in a leave vacancy. And moreover, there is no approval letter for appointing the petitioner against the said vacancy as an honorary grade 4 employee lawsuit. And there is also no approval letter for release of salary of the higher competent authority is found in the office of the inspector of school.
Where is Mr. U Sharma?
He is in court number in 3.
Place this matter on 13th, reflecting the name of Standing Council Finance in the cause list for the respondent number 4.
On 14 lodge will be possible. 14 lodge. 39 lodge. Difficult
On 14th.
lodge. Oblige.
Item number 7.
Malad, in this case, I need some accommodation, Malad. I misplaced the file in the office, Malad.
Page 98. Please take your seat. Yes, Mr. Dutta.
Lord, your petitioner, as the Lordship has seen, was serving as assistant professor in the Karimganj College. Now, pursuant to the advertisement dated,
Now, this Karimganj College, just tell us one thing. You are serving in the Karimganj College as a regular assistant professor.
yes,
Your selection was done in terms of the advertisement and all.
my,
And your advertisement, pursuant to that advertisement, the selection, your appointment was approved by the Directorate of Higher Education.
that was, my Lord, is a self-financed college.
Oh.
So therefore, those sort of things were not there.
It's a,
Therefore,
it's a
my lord,
Karimganj college affiliated to Assam University and not under the, it's not a provincialized college.
Exactly. So therefore, pursuant to this advertisement,
Okay.
my Lord, he participated. And how, my Lord, the selection process was conducted. Lord, I would like, first, my Lord, I would like to take your Lordship to the MP in order.
No, we are not on all these things. You applied and your case was, you are placed in a particular position. And the concerned candidate whom the appointment was offered did not accept,
Right.
right?
Yes,
And since you are thereafter in that particular category, so according to you, you should have been offered with the appointment. Number two, the observation made by the respondent authorities in the Directorate of Higher Education that your MP and other things. What we have noticed from the annexes, which the petitioner has annexed, there are same annexer in two different same copy. One is at page just a minute, coming back. Your annexer 16 and annexer 24, it is the same communication,
16 and yes,
right?
well,
It's a letter from the UGC.
exactly.
Now, if you read a reply to you given by the UGC,
Yes,
which you have obtained through RTI, point number one, kindly read
at page 67.
anyone, whether it's annexer 16 or
Yes.
24, doesn't matter.
Now, the Distance Education Council has accorded post-facto approval to the Annamalai University, Annamalai Nagar, Tamil Nadu, for offering programs to distance mode from the year 1995 to academic year 2006-2007 for the programs approved by the statutory bodies of the university. It is for the university to follow the norms prescribed by the concerned regulatory bodies or seek their recognition for profession technical programs as per the requirement. As per the recognition letter, the territorial jurisdiction of the university will be as per its acts and status.
Now, what we have seen from your petition, that while the petitioner was serving in this college, Karimganj College,
Yes.
he obtained his MPhil degree from Annamalai University in the year.
2008. But
He
for-
obtained his MPhil degree.
Well,
Now, of course, he obtained his PhD degree from Assam University.
yes,
Now, one more thing we have noticed that you have also obtained your MA from MPhil
empty.
from Annamalai University.
Yes.
Your MA is from which university?
This MA is from possibly Guwahati University.
MA is from. Now, your this MA, MPhil degree,
Yes,
which you have obtained through distant mode,
no,
right? Uh, For that purpose, recognition is the last paragraph of the point number 1,
yes,
that it's to be within the territorial jurisdiction of the university as per the acts and status of the said university.
yes.
Now, kindly tell us, because it's a what we have noticed in the letter of the Annamalai University, which you have annexed
Yes,
along with your petition, it's very clear that it has been constituted. It's a state university. You can come to page number 65,
yes,
the first paragraph itself,
yes,
established by an act of the state,
right.
right? And has been recognized by the government of Tamil Nadu.
Yes,
Now, can you tell us what is this particular territorial jurisdiction of this particular university?
that is my lord Tamil Nadu.
So, if the particular act of the state act allowed this particular university to confer degrees in the distance mode, and in terms of this letter of the UGC, it should be within the territorial jurisdiction of the whatever is available in the act. And if that act has only permitted the territorial jurisdiction of the state of Tamil Nadu, any degree conferred by that particular university outside that territorial jurisdiction, will it be a valid degree? For example, let us see that Guwahati University is having IDOL. Then there is another Krishna Kanta Handik Open University. Similarly, Dibrugarh University is also having their distant mode education. All these are through the state act, which has been approved. And it has a territorial jurisdiction. They cannot go beyond that territorial jurisdiction. So normally you will see the candidates from Assam either will be a student of IDOL or from Krishna Kanta Handik Open University or from the Dibrugarh University. Now here is a case, the person who is a resident of Borak Valley through a distant mode obtained his MPhil degree from Annamalai University, which has the jurisdiction of only in the state of Tamil Nadu. If you go by the UGC regulation,
Yes,
then only it can have to be only on that particular state, because whatever is a territorial jurisdiction given by act, in some of the universities conferring such degrees on distance mode, they have said it will be within their campus only, not beyond their campus. So they cannot open a campus somewhere in the another part of the country. So whatever degree, it has to be within that campus.
Yes.
It's very interesting to be known, because UGC earlier Distant Education Council was there, it was taken over by the UGC later. So first you have to tell us that in terms of this particular answer made by the UGC to you, you have to establish whether this Annamalai University had the territorial jurisdiction to confer such MPhil degrees to the state of Assam or not. You see, in the case of Dr. Yashpal,
yes,
the Honorable Apex Court has laid down that law very well,
Yes.
because you have seen numbers of such universities in the Bogas or whatever in the state of Bihar and other states are conferring degrees. That's which have low down the standard of the education. And Professor Yashpal himself was a very nominated person. There, everything was been dealt with by the Honorable Apex
Yes.
Court. So there you will see one particular thing, such acceptance of degree conferred by distance mode in another state is possible when that particular state accepts, and that acceptance is not through a notification, it has to be in the cabinet. All these things has been dealt with. And then say, for example, that degree of Annamalai University, the distance mode degree they are conferring, if it is accepted by the state of Assam in its cabinet and thereafter issues a notification, it will be a valid degree for the purpose of giving any such degree to distance mode. Unless you tell us from whatever, from the state of the act of the establishment of the Annamalai University. If it has the jurisdiction outside the permissible limit, then this MPhil degree of your will not have any value for acceptance. This is one. And the next notification of the UGC is very clear that the period of teaching while doing MPhil or PhD will not be taken into account as a teaching experience. Those teaching gives, you are entitled for 5 marks as you claim
Yes.
for MPhil and this thing. Now for PhD, you are not saying anything. But thing is this, but for your MPhil, you have to establish that you are within that jurisdiction.
Yes.
Unless you can show that we cannot proceed. Third is, if somebody is selected, appointment has been issued, the concerned selected candidate did not accept that appointment and surrendered. The process of selection of that particular post is over. That's the law laid down by the Apex Court. Because nowadays you will see one post, only one selection, final selection. And that one, nowadays you'll never see any such waiting list. Because of the law laid down by the Apex Court, the waiting list, unless it is in the rules, these are concerned service rules, it will have no
So
effect.
for this third point, my counter would be, my lord, I am not saying that since he did not took the appointment, therefore the right has been accrued to me.
Your thing is
My
that you are
question
entitled
is
for 5 marks, by which
selection-
you'll be
Yes.
above that,
Exactly.
right?
I'll
So
satisfy your lordship.
that thing is this, that 5 marks, first of all, if the UGC regulation came long back,
No, there,
prior
my lord,
to-
I have the explanation. I will convince you.
so while doing any PhD or MPhil,
My lord,
that
while-
teaching experience,
While doing PhD, if I do not take leave, if I do my duties, and then I do impart the education, in that case, my lord, there is a rule of the government that the marks per year I'll have to give one.
have you made UGC a party? Because that particular notification is of the UGC, not because of the state, and state
No, no.
complying with the UGC notification.
That, my lord, I will lordship.
Unless UGC clarifies, the state clarification, state has adopted the UGC notification.
My lord, if your lordship look at page 86 for a while.
Yes, please.
The second para, the clarification university grant commission is as follows. The period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment promotion to the post of associate professor and above. So therefore, they have committed wrong, and strangely enough, your lordship will find 3 of the centers, my lord, the same examiner, they have allotted 5 marks in the 2 areas, and where the third place, my lord, they did not give any marks. How it can happen when you are satisfied in 2 of the places that he should get 5 marks on teaching experience, in another Dolgao you are giving 0.
The post was for which this thing?
Assistant professor. Assistant professor.
Assistant professor. And read this particular.
The period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment promotion to the post of associate professor and above.
Will it be applicable to you?
My lord, these.
The UGC has not extended to the assistant professor.
my
It
lord,
has given benefit only for the purpose of associate professor and above.
the analogy can be drawn.
We can, this we have to read as a whole.
Truly, my lord, your lordship will find even
See, regarding any such academic matters, you'll see when these matters been approached before the Honorable Apex Court also, they have clearly laid down that the court in exercise of the power under Article 32 will not go beyond this because these are purely academic matters. And whatever is benefit by the concerned authority formulated under an act, because there is an act, UGC Act is there, which is the Parliamentary Act. And under that act, they have framed the rules or regulations, which is having the statutory power, cannot be diluted by exercising the power under Article 32. So it has been to be read as a whole. So here, this particular benefit that has been given is only to the associate professor and above, not for the purpose of assistant professor. But you will see again the same thing if you read. There is a UGC regulation. You have annexed. This is a regulation of 4th May 2016, 103, page.
Yes,
At 104, 3.3.1.
yes, this
Right.
is, my lord, this is talking about the person who is not, who has taken leave and prosecuting his studies
Right.
is applicable. for
Then
that.
followed this, 3.9.0, 105.
This is, yes, I'm reading it. The period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions.
Mhm.
Now, whether it is applicable in my case,
This has come when? 4th of May 2016.
yes,
And the letter which you have shown just now, where from you are requesting the court to make an analogy,
Yeah.
that is of 1st March 2016.
right,
And this particular notification or this particular clarification given by the UGC
Yeah.
definitely override by 4th May 2016.
no, my lord, the question would be, your lordship kindly, if we go in between the lines. Now it
See.
says, if I am not discharging my duty, I am taking leave, then there is no teaching experience at all.
See, that is the reason we're asking you. Have you made UGC a party here? Who at best, who can give this clarification? Not the state of Assam, because state of Assam has to follow it in toto.
Look, since UGC is not a party, we may be allowed to make them a party. After all, my lord, substantial justice is required.
Yes, yes, that's the reason. You should have made a party. That is why not dismissing the petition at this stage.
And so far, the first question is concerned, my lord, the government has to give a lot of answers to this question because the lordship will find 2006 onwards to 2013, from these very university Annamalai and then other universities.
See, Mr. We have seen, you have also annexed certain other things.
Yes,
But the reason is, if somebody might have been considered, and it should be considered also in your case, that kind of negative ability, as you know,
No,
the
no,
ML Apex Court has
negative
laid down.
concept will not come, but can it be said to be negative concept? More than 104 teachers were appointed, given promotion. They were in contract service. They have been made regularized on the basis of MPhil degree got from the private universities. Now, can it, so far I am concerned, I'm a person as if I'm a foreigner. And
Look
how
into
I
that
have been-
aspect.
I have been dealt.
We look into that aspect.
Even in the selection criteria, you also will find very unpleasant things. Contrary to the provisions of Article 14, 15, 16, the selection committee has decided my case against me. Well, the constitutional provision also they have forgotten.
Heard. Mr. S. Dr. Lanit, Senior Counsel. assisted by Mr. S. Dr. Udin Beckett Jr. Jair for the petitioner. And Mr. S. Das, Standing Council, Higher Education for the respondent numbers. All respondents, because you are representing this. Which respondents you are applying?
One and two, my
I think government is also appearing for this particular college.
Yes,
Pandit Deendayal Upadhyay.
right.
Mr. Gogoi earlier informed us that is the government college. While adjudicating the matter, the court found that the University Grants Commission, represented by its secretary, is a necessary party for proper adjudication of the case. In view of the above, the University Grants Commission, such and such, represented by its secretary, such and such, for adjudication, be implemented as party respondent number 12 in the present proceeding. Registry shall accordingly correct the cost type. Petitioner shall serve extra copies of this writ petition, including the annexes appended thereto. The copy of the affidavit filed by the Director of Higher Education, Assam, along with its annexes. The to Mr. A. Sumua. And the copy of the rejoinder of the affidavit in reply of the petitioner to the affidavit of the Director of Higher Education, Assam, along with its annexes, shall be served in the Standing Council on Mr. A. Sumua, Standing Council, EGC, within 2 days from today. 2 copies given of the necessary acknowledgement from him in that regard. List on 16th of February.
A little letter, can it be, madam?
1/1,
A little letter of 16.
21st.
Yes. Oblige.
Matter number 8.
And additional affidavit has been filed on behalf of the petitioner, my lord. It was filed on 3/1, but copy was served to us only on last Friday night.
Yeah, the additional affidavit which has not been served upon the department. Paying for the department. They have filed, they haven't served us any copy.
The petitioner has not served any copy of the affidavit or the
That,
respondent.
We have
We have got on Friday.
Private respondents are
I
not-
received the copy on Friday.
in our, it's not there, in our-
Please come this side because microphone, Gurua, microphone sound to it's not audible.
We'll check it out once, but we, at the moment, we don't have the additional affidavit. And,
Just a- Mr. Fukan, you have filed an affidavit.
Lordship, we have filed an affidavit, Lordship, on the last occasion, but this affidavit is not sufficient, Lordship. I have received another pair of instructions, Lordship, which I would like to, my lord, bring on record. Lordship. On the last occasion, Mr. Sharma had filed that affidavit, Lordship, and I have received it, my lord, in the last month. Lordship. We'll file it, my lord, within Friday, maybe. Lordship,
Yes.
another thing, Lordship, this additional affidavit which they have filed, Lordship, which we have received today, Lordship. This also, my lord, will be required to rebut, Lordship. Filed by the petitioner.
Yes, now tell us
My lord,
your appointment order as of which date?
my lord, appointment on, my lord, 8/1/1996, my lord.
Good.
My lord, kindly go to page number 20, my lord. And I
Just a minute. What is your appointment order number?
page, my lord. At page 14, my lord.
Okay. What is the number?
9318 22 dated 8/1/1996.
Good. Issued by the DEO Karimganj.
Yes,
You have been appointed as an Assamese language teacher
yes,
in this particular ME school in district of Karimganj.
yes.
Good. Now, where is your regularization order?
Declaration, my lord, at page 16, my lord, and exact 2.
Hmm.
Type copy, my lord.
Huh.
It is at the middle portion, my lord.
Hmm.
Memo number 3815 dated 26/6. So and so by so and so and 8196 extended so and so by so and so. This is the extension order.
Where is that extension order?
Numbers are there, my lord.
Now, where is that extension order?
Extension orders are not annexed.
Then how you are serving?
These are not annexed, my lord.
No, you must have, Mr. Uddin.
Yes, my lord, I have.
Give it us. Let us see, where is that order?
My lord, right now I have not.
Right now you don't have.
No, I have
When this order was passed for regularization?
11 June 1999.
Okay. So,
With effect from, my lord, date of joining, my lord.
just a second.
I have joined, my lord.
See, your initial appointment was ad hoc appointment for a period of 4 months.
Yes, ma'am.
There was no selection, nothing.
Yes.
An ad hoc appointment was for a period of 4 months an Assamese language teacher by the DO Karimganj by this particular memo number. Now, when did you join?
On 10/1/96.
On 10/1/96.
Yes, ma'am.
Okay. You joined on 10/1/1996.
Regularized, my lord, with effect.
Just a minute. Just for a period of 4 months. So January, February, March, April, right? This period was for 4 months. Then you say your appointment was extended, right?
Yes, ma'am.
By the order of the DO Karimganj,
Then, my lord, 12/5 next order, my lord.
12/5/96.
Yeah, my lord. And then, my lord, another order, my lord,
Huh?
19/9, my lord.
Huh? No, that is what we want to know.
2/3.
Unless just initially you were appointed for 4 months.
Yes, ma'am.
You served up to April. Then another order was issued in
May, my lord.
May,
Yes, ma'am.
by which your service has been extended
Yes.
for how many months?
Till issuance of this regulation.
No,
order,
no,
my
no. See, unless your service is extended year after,
Yes, ma'am.
question of regularization will not come. Because, say for example, your ad hoc appointment initially, which was for 4 months, was subsequently extended by this letter for 12/5/96. There has to be something in that letter.
Yes, my lord. There is
Has to be something.
last time, my lord, until further order to standard.
Where is that?
This is not there. My I have annexed, my lord, service book, my lord, in the additional affidavit.
Where is that?
In the additional affidavit.
In the additional affidavit. Additional affidavit. When did you file?
So filed on
Okay, you got it. Additional affidavit. Yes.
12 December.
Mm. Where is that? Can you show us that it was until further order?
Part, my lord.
Where is that order?
Services transfer center by November. But this is specifically not there, my lord, but
Then, so let us assume that you have not been, if it is until further order, very good. If it is not there, you have been appointed for a particular period. That period would have been over by that 4 months,
yes,
May, June, July, and August. Now, while you are not in service after August 1999 or 1996, whether by an order your service can be regularized. So unless you show us that order of the DEO by which your service was extended, how should we accept that you are a senior person?
my lord, this regulation order, my lord, the initial appointment.
No, that's the difficulty.
And my lord, now, my lord, in my additional affidavit, I filed the select list, my lord.
That is it. Everything is wrong. That is the thing. You are challenging the seniority.
Yes,
You are
issue-
challenging the seniority.
Yes, my issue is the seniority, my lord.
Now, if your seniority, uh, why does seniority based selection has been made for you, right? That you are eligible for the post of headmaster.
Yes,
Where is the gradation list?
this, I have a next, my lord.
Gradation list.
Gradation select list.
You have made the selection list. Whether can be any such select list without the gradation list,
There might be some gradation.
you are not aware. So unless there is a gradation list of ME school, of that particular education block, the madrasa, ME madrasa, right? It will be category wise.
Ultimately, my lord, select list has been issued.
There has to be an MB school, the gradation list. Only then the other persons whose names are there, they will be able to challenge.
On the basis of this, my lord, select list issued, my lord. And as
Mr.
far,
Fukan,
as far select.
how
list-
you are managing your department, we do not know. But the law is very specific. Law is very specific. Okay. There is no such order extending the service of the petitioner.
Yes, my lord, there is
After-
order, my lord. Until further order, there is an order.
Where is that order?
My lord. And we allow some time, my lord.
No time today. You have enough of time.
It is not next, my lord.
So that order of extension issued by the DEO regularizing the service of the petitioner from the date of his joining, unless verified on records, right? We do not know. Second part is the DEO, while regularizing the service of the petitioner, there are 5 or 4 persons, they have 5 persons. Referred a letter of the director that was of 31st of March 1999. Okay. 31st of March 1999. To find out
No, no, no.
what is that letter,
The ELM 529729. That one.
what was the direction given. That is one part. Secondly, come to the respondent number 5. Respondent number 5 has filed an application, filed his affidavit.
We have already filed our affidavit.
Now, A managing committee of a provincialized ME school allowed the respondent number 5. Managing committee of a provincialized ME school allowed the respondent number 5 to work as an honorary Hindi teacher. Honorary Hindi teacher. The resolution was of August 1990, and the petition respondent number 5 joined that school on 1st of September 1990 as an honorary Hindi teacher. Now, as there was on the ground that there was a requirement of second Hindi teacher, considering the enrollment. So, what the petitioner has done, as his service was not regularized, a person appointed by the managing committee of a provincialized ME school without any advertisement and without any selection against this thing, an honorary teacher, the headmaster wrote for regularization of his service. Since the government did not regularize, he approached this court, preferring a writ petition. Civil Rule 2144/95. And in that writ petition, the court observed as follows. If you see that order, he has annexed. Now, read that order, which is at page
21.
52 or 18. What a court passed that order. 24/5/96 order. Kindly read.
Page 21.
It is page 18 of the affidavit of the respondent number 5.
And in this civil rule, the petitioner has moved this court for an appropriate direction for regularization of his service in the school where he is serving. The petitioner states that he has passed 3 years degree course with Hindi as a major language and fully qualified for appointment as Hindi teacher. In addition to that, petitioner also passed COVID examination conducted by the Rashtra Bhasha Prachar Samiti, Wardha in the year 94, and diploma in English typewriting. Petitioner is serving as Hindi honorary teacher since 1990, 1990 in Panaibond Adolpha ME School. Until date, he is working as such. He also said that his mother, Vidya Roy, was headmistress of 728 number so and so, and she died in harness on 16/4/84. According to the petitioner, a post was fallen vacant due to sudden demise of Sumi Tiwari in Panaibond ME School. Petitioner said that he submitted a representation for the respondent number 4, which was duly recommended by the headmistress of Panaibond ME School, praying for regulation of his service in the vacant post. Thereafter, several representations have been filed before the authority, but no action has been taken by the respondent. In fact, the facts and circumstances of the case, I find no reason for not considering the case or the petitioner for appointing him as Hindi teacher, if he is otherwise qualified for the said post. Accordingly, in the fact and circumstances of the case, I direct the respondent 4 DEO to consider the case of the petitioner and shall pass appropriate orders considering the existing government policy in this regard. The entire process of consideration shall be completed within a period of 6 weeks from the date of receipt of the certified copy of the order. With the aforesaid.
The court very specifically passed an order
Right.
that the case of the respondent number 5 to be considered by the DEO concerned after considering the existing government policy in that regard.
Well,
Come to page number 23.
23. My lord, in pursuance of the order passed on 24/5/96 by the Honorable Guwahati High Court in CR number so and so, the appointment of Shri Divakar Rai, honorary Hindi teacher in so and so, wife so and so, as honorary Hindi teacher who has been working as honorary Hindi teacher since 1990, is hereby adjusted to the post of Hindi teacher, Fanarband Adarfa ME School, created due to expiry of so and so in the pay scale of so and so, or as the government scale sanctioned from time to time, plus other allowances as admissible under the government rules with immediate effect.
And when that order was passed?
It was passed, my lord, 30/10/98.
So that was its immediate effect means 30/10/1998.
Right.
What was the government policy?
Hello.
What was the government policy that was adopted by the DU? Because the court direction you have reduced as per the government policy. What was that government policy? As the DU mentioned.
My lord, the government policies are not.
Now, interesting case is that the petitioner approached, the respondent number 5 approached this court in CR 2144/1995.
Yeah.
He filed a writ petition, as we have in our hands, on 30th of May 1995. The prayer of the petitioner in that the respondent number 5 was that his service should be regularized as a junior Hindi teacher to keep one Hindi junior post vacant in that particular school due to expiry of one particular teacher of that school, and to pay him a consolidated sum of rupees 900 per month. That was passed, that was he filed in 1995. The ground taken by the respondent number 5 was that his mother,
Died in harness.
Vidya Roy, was a headmistress of 1728 number Lalsara Hindi Lower Primary School in Karimganj district. She expired on 16th of April 1984. And on attaining the age of majority, he applied for his compassionate appointment on 5/5/1986. In the meanwhile, he obtained his graduation, 3 years graduation in the year 1990. He applied for selection. He was not selected. Then he approached the school. And the managing committee of this particular provincialized school is very categorically, he mentioned in his writ petition that it is a provincialized school. On 25th of August 1990, resolved to appoint the petitioner as a second Hindi teacher on honorary basis. So, since his application for compassionate appointment was forwarded, he prayed before the court that his service should be regularized in terms of the government notification of 9983 for compassionate appointment. In that particular office memorandum of 9983, the first notification for compassionate appointment, which the respondent number 5 annexed, the personnel department of the state, though did not specify the limit as to when such application is to be filed. There very specifically said such consideration for an appointment under the scheme on a compassionate basis, diet and scheme. The authorities will keep it in mind that the concept of compassionate appointment is limited to the need for immediate assistance. If several years have passed after the death of a government servant, it would appear on the face of it that the family has managed to support itself all these years and has some means of subsistence. In such a case, compassionate appointment would not ordinarily be justified. Application for appointment under the said scheme should be carefully examined from the point of view of immediate need for assistance to ensure that only the most deserving get the benefit of the scheme. It was the scheme of diet harness, the state government for any such government employee dies with harness. So the petitioner only on attaining the age of majority applied, and he approached the court in the year 1995. Accordingly, court passed an order considering the
Case of the
government notification, government policy. The case of the petitioner should be considered by the DO for instance. We have seen the result, what kinds of consideration there. It is very categorically that mother of the petitioner expired in the year 1984, April 1980. And the DO concerned considered his case. Though there is a specific order of the court that it should be considered under the government scheme or government notification in terms of that order, it is very clearly court has passed that order. That government policy, right? That's one number 5, but the DO has passed that order allowing the service against that post. That is with immediate effect. And that order was passed on 30/10/1998. So at best, the response number 5, service is born into the cadre in terms of this order only on 30/10/1998.
30/10/98.
98,
98.
not prior to that. He was not in the any cadre
Yeah.
or in a government post.
Right.
With regard to the petitioner, his service has been regularized, assuming that his service was extended until further order, and his service was regularized by the DO Karimganj on 30/01/98.
99.
90,
9.
30/01.
1999. 11/6/99.
11 June 1999. Now, even if his service is regularized, the law is well settled, any such ad hoc appointment cannot be considered for the purpose of seniority. That's the law. In that regard, government of Assam has already passed an order. If you see, the ad hoc appointment comes on the under APSC regulation. There is no such provision of ad hoc appointment in other rules. Only the APSC limitation and function rule says about the ad hoc appointment. They are very categorically stated that even if regularization is there, the term of ad hoc appointment will not become under the permanent be considered for the seniority. Right? You don't know your directorate are filing affidavits without having, and you are also relying on such affidavits. Not assisting the court, neither the petitioner nor you nor Mr. Das. Only you are carving up on their own clients. That will not do. This is the court of law. And then you have to decide this in it. We'll send down the matter. Now petitioner has come across saying that his name has been selected for the post of headmaster in a ME school.
Both respondent name was also selected. my lord.
Where is that?
He is junior to me. At my lord, serial number page 198. my lord.
198.
Serial number
Serial number 198.
189.
189.
Yeah, at page 18. my lord.
There's one thing, my lord, I want to point out.
His name was also selected by the
Hmm.
his junior, my lord.
Hmm.
To me, my lord.
No, first of all, while select list or this is a gradation list.
Select list, my lord.
If it is a select list, there has to be a gradation list.
It is a select list, my lord. Select list of teachers in respect of ME school for promotion.
Where is that circular of the government? The recent circular for regarding selection of headmaster, headmistress, superintendent in ME, MB and Madrasa, Mr. Fukan. Where is that notification? Where is that notification? There is a recent notification issued by the government, the Elementary Education Department, regarding selection of headmaster. You are not aware?
No way, my lord, I don't have it at the moment.
You should have it. Keeping at home will not help the court to pass any order. Give it to us. See how you are assisting the court. All of you, the way you are assisting the court, you can understand. Get hold of Mr. Sisti or Mr. Mazumdar.
There's one aspect perhaps which deserves your lordship's kind attention. my lord.
Please.
There's one thing I would like to point out. The services of the petitioner was respondent number 5, my lord. It was regularized with effect from 30/10/1998.
What is the order reads?
That 30/10/1998, my lord, I've annexed it in page number 23 of my affidavit in opposition. If your lordship kindly takes the affidavit in opposition filed by me, page number 23, my lord.
You are saying that you have joined that school in 1990,
I have
and that is why your seniority should be
no,
counted
that is
from
not my point, my
1990.
lord. My point is on a slightly
Now, when
different.
did you born in the cadre?
I was
when-
born in
when?
I was born in the cadre on 30/10/1998.
Then how come your past service will be
No,
considered?
I'm not on that, my lord. I'm
Then-
on a slightly different footing, my lord.
Yes.
All I'm trying to say was that the respondent number 5, he was born in the cadre on 30/10/1998.
Hmm.
And the petitioner was born in the cadre on 11/6/1999.
That we have seen.
That your lordship has seen.
That we
Now,
have said, expressed everything.
The only contention of the petitioner before your lordship is that his services were regularized retrospectively. And he wants to say that since his services were regularized retrospectively, therefore, he should be given the benefit of seniority over the respondent number 5. That is his only case, my lord. And in this regard, my lord, if your lordship wants to peruse, my lord, the matter, the issue has been settled by our honorable court, my lord. If your lordship kindly takes up.
Mr. Mazumdar. Earlier, there was a notification for selection of headmaster, headmistress, superintendent in ME, MB and madrasas, right? ME madrasas. That was prevailed for a long time. In between some change, again that was removed and another came. But few days back, Mr. Sisti placed a particular notification of the government regarding the procedure to be adopted for a selection of headmaster, headmistress and superintendent in such ME, MB and ME madrasas. This was of 2018, 19 or something, very recent, very recent.
Yes.
While that Mr. Pritam or what that, he was the commissioner secretary. You have that?
I've given the case law.
Just a minute, we'll come back to that.
My lord, my lord.
Yes, what do you like to show,
Well,
Mr. Das?
Illu Bora Soikia, my lord. This issue has been settled, my lord. Identical issue. May I just take your lordship to the facts first, my lord? Paragraph 2, my lord. The petitioner was appointed as an assistant teacher in the scale of pay of rupees so and so in Duliajan Utsav Vidyalaya ME School. Such appointment was made as per order dated 27/10/1993 of the DEO Dibrugarh and was approved by the Subdivisional Advisory Board as required under the rules. Now, if your lordship kindly comes to the next line, the respondent number 6, on the other hand, was appointed by the school management committee of the school on 26/2/1990 as a Hindi teacher, my lord. So these are the facts, my lord. And the basis of the claim is at paragraph number 6. I will not trouble your lordship with the entire judgment, my lord. I'll only point out the relevant paragraphs. Next is paragraph 6, my lord. May I just read out, my lord? May I just point out paragraph 21, my lord?
You have seen that.
May I just read out, my lord?
You have seen that.
Now it says, my lord, especially paragraph 23, subparagraph 4, it says the seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressly provided by the relevant service rules. It is so because seniority cannot be given on retrospective basis when an employee has not even been born in the cadre. And by doing so, it may adversely affect the employees who have been appointed validly in the meantime.
So you want to
Now,
say,
if we import this,
you want to say that you born in the cadre on 1998
I was born in 1998, 30/10/1998. My services was regularized.
and the petitioner born in the cadre when?
Petitioner services was regularized in 11/6/1999. So therefore, my lord, where is the question of his seniority over me, my lord? Just because it has been given retrospectively doesn't mean, my lord, because it has been settled. Now, if your lordship kindly turns to the next paragraph for one moment, paragraph 25, my lord. Paragraph 25, that is the concluding part. It says, in view of such conclusion, the factual basis on which the order dated 28/7/2014 was issued that the service of the respondent number 6 was regularized with effect from 16/11/1991 is found to be incorrect. Further, by following the law laid down by the Honorable Supreme Court in Direct Recruit Class 2 Engineering Officers Association Supra and Pawan Pratap Singh and other Supra, and even otherwise, if the services of the respondent number 6 was regularized with retrospective effect from 16/11/1991, still the respondent number 6 would be entitled to all other service benefits of such regularization from a retrospective date, but she cannot be given the benefit of seniority over others on the
That's
basis
a
of such.
law long back. That was already been mentioned.
It's a settled law, my lord. And this
This law has been already settled long back.
and
but
this
yes.
has been relied on the basis of Pawan Pratap Singh, my lord. Pawan Pratap Singh, if your lordship kindly takes for a moment, Dada. I'll just place two paragraphs of Pawan Pratap Singh, my lord. I'll not trouble your lordship with the entire judgment, only the relevant portion, only two paragraphs. Paragraph 29.
Just a minute. Mr. Muzumdar, ask if that is not ready level, will you get it in your map and give it to us by 2 o'clock?
Yes. History has it, my lord.
You might have it. It was given, but it was in a particular case record. Yes.
My
What
lord,
do you like to show?
Pawan Pratap Singh, I'll not trouble your lordship with the entire judgment. I'll just point out the two most relevant paragraphs. Paragraph 29. If the lordship kindly turns to paragraph 29 for a moment. Paragraph 29 says, my lord,
Yes.
it says the constitutional bench of this court in direct recruit class 2 engineering officers association versus state of Maharashtra and others stated the legal position with regard to inter se seniority of direct recruits and promotees, and while doing so inter alia it was stated that once an incumbent is appointed to a post according to the rules, his seniority has to be counted from the date of appointment and not according to the date of his confirmation. From the above, the legal position with regard to determination of seniority in service can be summarized as follows. Now, if your lordship kindly turns to the next page,
That has been
and
already
subpara
there in
4.
the judgment of Brother Justice.
Yes, my lord.
It is already there.
My lord, my lord. It says, subclause 4, it says the seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively
Same thing.
unless it is so expressly provided by the relevant service rules. It is so because seniority cannot be given on retrospective basis when an employee has not even been born in the cadre. And by doing so, it may adversely affect the employees who have been appointed validly in the meantime. Now, my lord, I was appointed validly in the meantime on 30/10/1998. Now, if the petitioner is given retrospective seniority, my lord, it will affect me. He will get all other service benefits like pension and other benefits, but he cannot get seniority over me, my lord. It is a well settled law, my lord. That is my humble submission before your lordship.
Declaration effect has been given this. Seniority was not.
Just because it is mentioned,
10/1/96 years.
it will be against the mandate of the Honorable Apex Court, my lord.
And regularized on that date, my lord, against a substantive vacancy, my lord.
My lord, two dates are very
I am
important.
senior, my lord, to the respondent of 5.
One is 30/10/1998, the date on which I was regularized, and the second date is 11/6/1999, the date on which the petitioner was regularized. So when we conjointly peruse these two dates, my lord, I am anyway senior to him, my lord.
As per select list, my lord, I am senior.
Hmm?
As per select list, I am senior to the respondent of 5.
Similar issue has already been dealt in Billu Bora Sakya, my lord, by this honorable court.
Mr. Majumdar, you got it? Okay, give it to us. We'll pass the order at 2. All right.
Order number 2.
My lord, I am sorry, my lord. That was when I was busy. Yes, ma'am. Please start.
The petitioner is before your lordship, my lord, challenging her termination from service without following the due procedure of law, my lord. No show cause notice was issued to her, that is the allegation. No inquiry as such. The show cause notice which was served on her was antedated, and my lord, it was served quite after some, after expiry of the.
Just tell
previous-
us one by one.
Yes, my lord.
You served in which school?
I was serving in Dimrang ME School in district of Dima Hasao, my lord. She was appointed in 2002, my lord. 1/8/2002.
Have you annexed the appointment order?
Yes, my lord, 1 and 2 annexures. It was by the managing committee. My school was not provincialized at that point of time.
What is it?
Mr. Sisti, it's not coming in net because we are trying here. When did you join?
And I joined on 2012-2002, my lord. Annexure 2, my lord, page 15.
After so many days. More than 3.5 months. August, September, October, November. 4.5 months.
August 2000.
Anyway, it's not a provincialized school at that point of time. We're not nothing to do. You have been directly appointed as a headmistress.
Yes, my lord.
Then what happened?
And subsequently, my lord, I was rendering my service, you know, for 10 years in that school.
Your service was approved.
Approved, my lord. It is, my lord, at annexure 3, my lord. Annexure 3, page 17, my lord.
Okay. Then
Now, my lord, after that, my lord, another person joined the headmaster of the school, my lord. In 2011, my lord. Till then, she was discharging her function as headmistress of the school. And in 2011, my lord, another person joined, my lord. And then that point of time, my lord, petitioner had conceived, my lord, a child. And the child, for that was the period, my lord, when all these problems started. She availed some leave that time, my lord, during her pregnancy. And child was delivered on 16 to 2012. And that period of time, my lord, she could not attend school regularly.
just
And-
tell us one more thing.
My lord.
When this school was provincialized?
School was provincialized, my lord, subsequently. February 2012. my lord.
Okay. So the school managing committee appointed someone as a headmaster,
Right.
respondent number 6, I think so.
6. my lord.
And approved by the inspector.
Yes, my lord.
Okay. Then what happened?
Thereafter, my lord, the show cause notice was issued on 37/2011, my lord.
Hmm.
Now, that letter, my lord, reflects, my lord, the 7 days time was given to the petitioner to reply to the, my lord, show cause. While the date was, my lord, it was 37/2011. 37. It was delivered to the petitioner. My lord, I have stated in the paragraph 5. It was delivered to the petitioner on 20/10/2011 after expiry of 2.5 months from the date of issuance, my lord. And subsequently, my lord, a termination order was served on petitioner on 28/10/2011, my lord. And she was shown to be terminated with effect from 13/8/2011.
Where is the termination order? Which date?
It is, my lord, annexure 6, my lord.
No,
Show
which
cause,
date?
my lord, date is 28/10/2011.
that you received.
I received on 28/10. It was dated 13/8/2011.
No, 13/8/2000 terminated from 13/8/2011. But when this order was issued, but when this letter was issued,
My lord, Annexure 6, my lord, is the termination letter. It is not dated anywhere, my lord. It is said that you are terminated from service with effect from 13/8/2011.
yes, then
Then, my lord, I had approached the authorities, my lord, the higher authorities, narrating the facts that during the period of pregnancy, I had availed leave. And during that period of time, my service could not have been terminated like that, my lord. And the petitioner was replaced by one of the near relation of the president of the managing committee, my lord.
those are not to
My
be
lord.
considered.
The representations are Annexure 8 and 8A, my lord.
When did you file this petition?
It was filed in 2014, my lord. April 2014.
What is the stand of the respondents?
My lord, they are saying that I was habitual absentee, and therefore, my lord, they had conducted some inquiry and they had terminated. my
Now
service.
the inspector of school is defending the order of the non-provincialized school. Because you said the school was provincialized in February 12.
12.
And the inspector of schools, Dimahasa, is defending an order of a non-provincialized school.
Respondent number 3 has filed this affidavit.
Who is respondent number 3?
Inspector of Schools, Manoj Mahasa.
Yes, Mr. Khanikar, whether just tell us private respondent appeared or not.
Manoj, one point, I mean, also clarify, Manoj, in my affidavit, in a rejoinder affidavit, Manoj, I have also pointed out that they, whatever they are saying that I have, in the affidavit, they have taken a stand, I have joined another institution. That was during the course of my service to that institution, and Annexure 1, I have enclosed in that rejoinder, Manoj, that I had obtained permission from them, Manoj. Worked in Harindaja Junior College, is lecturer in Bengali. As a lordship found it, Manoj.
That we have seen.
President of the managing committee had allowed.
Mr. Khanikkar, you have the record with you, right?
Madam, I have provided. Madam. General, kindly submit my affidavit, madam. Madam, one of my junior madam. Even madam, जब हंसा स्कूल में जगह दे कोई
Yes, Mr. Khanikkar, you like to say anything?
Madam, what happened, madam? The school was provincialized in the year 2013, madam. And madam, this all madam.
Provincialized with effect from when?
That was check that was not madam. Okay, madam.
Okay. So in 2013 itself, let us say.
12 or 13 itself, madam. Idea, madam. But the madam, factual madam, this all are happening in the year 2011, madam. So madam, managing director, madam, no, madam, the secretary is the best person, madam, managing committee, madam, to answer all the questions, madam. When I am not defending or madam, supporting any of the affairs, madam, and can I have a look, madam, page 2 of my affidavit, madam. Just we want to help
Yes.
the court to adjudicate the matter, madam. Para 5, madam.
You supported her case.
No, no, we are either not supporting or not. The records we have placed, madam, for this. जब हंसा स्कूल में टेस्ट इस
Um, Ms. Chakraborty, what is that full court judgment? Abdul Gafur Mandal.
Madam, which one is it?
Hmm? Do you have a copy of it?
That, Madam, Venture Education Act. No?
Ms. Fukan. Yes. Say something. Yes, Ms. Fukan.
15/2/0/27.
2000
15/2/0.
for what?
Abdul Ghaffur Mangal.
2015 to GLT.
337.
Yes, Mikun, you have the book with you?
Yes.
The old one you have, the new one you have? No, doesn't matter. It is here, I think so. The new one is there. Come to page number 2. Very beginning, page number 2. Kindly read it first. Page number 2. New book, new book. Yes, you are holding that new book, Ms. Fukan. Okay, page number 2. First page. The notification 3rd December. Page number 2.
My lord.
Kindly read that notification.
In compliance of order dated 19th March 2015, passed by the Honorable High Court in WPC number 461/2011, WPC number 6109/2012, and WPC number 2272/2013. And as per recommendation of the Honorable High Court, The governor of Assam is pleased to designate the court of district judges and additional district judges of each district to function as educational tribunal to adjudicate disputes relating to the teaching and non-teaching staff of the non-government educational institution as well as disputes concerning disciplinary action and claim for provincialization in respect of teaching and non-teaching staff of venture educational institution within their respective territorial jurisdiction from the date of issue of this notification.
Then, next paragraph.
Further, for this purpose, Governor of Assam is also pleased to include district of Dima Hasao, Karbi Anglong, and Baska within the jurisdiction of District Judge Court of Kachar, Nagaon, and Udalguri respectively until further on.
Earlier, Dima Hassan didn't had a district judge,
Right.
district and session judge. Now, since 2022, there is a district and session judge because he has made a judicial district, no longer under Kachar. The government is fully aware whether the education department has now extended this to Kachar or it is up to the district and session judge, Dima Hassan. Whether a notification has been issued,
Yes, under all.
get the information.
Right.
By this, the tribunal is Kachar or Dima Hassan. But there is a district judiciary where the district and session judge Dima Hassan has already been appointed long back, last year in middle.
Yes,
So let us know whether the government of Assam has issued such notification or not. If not, you have to do it because not only for the Dima Hassan, for Karbi Anglong and Baksa, all there are district and session judges.
right.
So this notification needs to be modified immediately. If it is not there, find out whether a district and session judge in these districts are not available. We have to do it. Anyway, we'll get back to you 2 o'clock, one by one. You said up to Gofur Mandal 2015, but you will get it. Click on notification. Dima Hassan district, Student Wicket Likhiva, asteroid. NC districts.
NC is for Autonomous Council.
NC Hills Autonomous Council. for the respondent numbers. Zero. Taravati Dikha, Chief for Standing Council Department of School Education. School within bracket elementary for respondent numbers 1 and 2, and Mr. Sasan. For respondent numbers 2. Office note, next paragraph. Clarifies that do notice on the respondent number 5 and 6. Were duly served. And the acknowledgement cards after such receipt have been received back by the registry of the school, but those respondents did not appear in the matter. The school managing committee of Dingrang DIMRANG ME School Ditokchera DITTOCKCHERRA Dima Hasab within bracket likha. Herein after referred to as the Sage School. Bracket close. A venture educational institution at the relevant point of time sentence to school managing committee is 11. Appointed on 01/08/2002, appointed the petitioner as its headmaster at rupees 1285 per month on the basis of the suggestion as well as the selection of the concerned selection committee. With the observation that her appointment shall be purely temporary and may be terminated at any point of time without assigning any reason thereof. Pursuant to the same, the petitioner joined her service on 03/08/2002. The inspector of schools not Kachar Hill District Circle / Mahasabpur Aflong on 16/02/2004 provisionally approved the appointment of the petitioner as a headmaster of said school. The president of the managing committee of the said school, file number A-1/2011, dated 30/07/2011, issued a show cause notice to the petitioner stating that in spite of repeated verbal instruction till the issuance of the said show cause, she did not turn up for her duties since the inception of the school, and that such reply should be furnished, should be submitted within a period of 7 days from the date of issuance of the said letter, intimating her father that failing on her part to submit such a reply, stern action will be taken against her as per departmental rules and regulations as deemed fit. The petitioner stated that she received the said show cause from the authorities of the school managing committee, that put in bracket SMC in short. SMC of the said school only on 2nd November 2011, but 02/11/2011. Further, the authorities of the SMC of the said school, paragraph 47, inform her that her service is no longer required in that school as she abstained from her duties since the inception of the school in spite of repeated verbal orders, and as she had already been engaged as an assistant teacher of Haranga Jao Junior College, HARNGAJAO, has been reported, specifying further that she has been terminated from her duties with effect from 13/08/2011. Forwarding the copy of the same to the Inspector of Schools, the Mahasau District Haflong, as well as the Deputy Inspector of School, the Mahasau District Haflong, for their information. The petitioner this time received her termination letter issued by the authorities of the SMC of the said school on 28/10/2011. The petitioner also came to know that the SMC of the said school on 13/08/2011 allowed one Ajem, AJEM, Harang Kol, HARANGKHOL, as the headmaster of the said school. Respond number 6 will equal as the headmaster of the said school, and that the Inspector of Schools, the Mahasau Haflong, on 01/10/2011 provisionally approved the said appointment of the respondent number 6 with effect from date of his joining. Petitioner submitted that she was regularly working in the said school since her appointment as the as its headmistress, and in that regard, she annexed the copies of daily attendance register of teachers of the said school as annexes consisting the name of the petitioner, and 4 other teachers of the said school. No, 5 other teachers of the said school. Okay. 4 other teachers of the said school and 1 grade 4. Petitioner submitted that the impune termination of the petitioner submitted that her impune termination from service as the head mistress of the said school, being in violation of law and without affording her any opportunity, being termination simplicity. And illegal, should be set aside in cost. Hence this writ petition is illegal, and as such he has preferred this writ petition, challenging her said termination order. Dated 01/10/2011. Issued by the authorities of the said SMC of the said school. Petitioners also pointed out that the so-called notice that was issued to her allegedly on 30/07/2011. The so-called notice that was issued to her by the SMC of the said school allegedly on 30/07/2011 was received by her only on 02/11/2011. And though the said so-called notice 7 days time was granted to her from the date of issuance of the said so-called to file her reply. And as she received the said so-called only on 2/11/2011, she could not prefer the reply. Further, in the meanwhile, the petitioner, prior to filing any such reply, the service was terminated from the said school with effect from 13/08/2011, and that she received the copy of her termination letter on 28/10/2011. Come on, noted above. The Inspector of Schools, Dima Hassau, response number 3, filed an affidavit in the matter. Stating that the appointment of the petitioner in the said school was during its fencer stage, and that the period in which the service of the petitioner was terminated the said school was in the ad hoc stage, where the SMC was the solely authorized to look into the matter of the school. The said response number 3, Inspector of Schools, Dima Hassau, also stated that as reported by the SMC of the school, the petitioner was on unauthorized absence for which the so-called notice was issued on 30/07/2011, to which the petitioner did not file any reply, and as such she was terminated from service. In the said affidavit, the Inspector of Schools, Dima Hassau, further stated that from the minutes of the SMC of the school, the said authority came to know that the petitioner has joined as a lecturer in a private junior college at Harangajao, in terms of our appointment letter dated 23/07/2008. And since she had already joined as a lecturer in the said junior college, the SMC of the school resolved to discharge her from her duties and to fill up the vacant post of headmaster in that school. The same was immediately filled up. In connection with the submission of the necessary proposal for provincialization of that school. And accordingly, the response number 6 was appointed as the headmaster of the said school. During the deliberation of the matter, Mr. Khanikar, Standing Counsel, Dima Hassau, on instruction submitted that the said school was provincialized in the year 2013 during the force of Assam Fencer Education Required. However, Mr. Khanikar, you pointed out something, no? That appointment is without something. You have said somewhere. Para 5 you mentioned,
But
no, there you have said that you have no role to play.
I have to, I have stated. Para 5(1), the appointment of the petitioner in the so-and-so school during the the period of in-person or still in the adult stage, the school managing committee was solely authorized to look into the matter of the school.
The response number 3 in her said affidavit stated that the SMC of the said school submitted the list of teachers serving in the said school before the district scrutiny committee for their provincialization. And that the name of the private respondent number 6 had been dropped from the final provincialization list. Since the interaction against the petitioner by the said school, authorities of the said school, was prior to provincialization, therefore, the petition filed by the petitioner being not maintainable should be dismissed. It is to be noted herein that a full bench of this court, in the case of Abdul Ghafoor Mondal versus State of Assam and others, decided on 11/11/2014, reported in 2015, 2 GLT 337. While determining the rights of
Where declared protected?
teaching and non-teaching employees which regard to their service in a venture / unaided educational institutions in the state of Assam. To establish the maintainability of writ petition. While observing that a venture institution remains a purely private body, though no writ petition is maintainable, but clarified that in a given case, where the decision of the authority of such venture institution is erroneous on the face of the record, or when adequate materials are available before the court, the writ court may itself decide to resolve the issue. In the said full bench judgment, the court issued a writ of mandamus to the state government to establish educational tribunals at the districts to adjudicate disputes relating to the teaching, non-teaching staff of the non-government education institutions, as well as disputes concerning disciplinary action and claim for provincialization in respect of teaching and non-teaching staff of venture education institutions. Pursuant to the same, the state government in the education department by notification number ELC oblique WP within bracket C 2272 oblique 2013 oblique 403 oblique 194 dated 201 dated 03/12/2015, as well as by notification number up to 403 194 196 dated 02/06/2016, constituted educational tribunal by notification considered educational tribunal to be chaired by the district judges and additional district judges of each district to adjudicate the disputes of teaching and non-teaching staff of such non-government education institutions, as well as disputes relating to disciplinary action and claim for provincialization that are applicable for elementary, secondary, and higher education department of the state. In the case in hand, the respondent number 5 and 6, the authorities of Saidpura school Khonana, as well as the private, that's number 5, as well as the respondent number 6, in spite of receipt of notice, did not appear in the matter as noted above. As such, the allegations made by the petitioner against those respondents without being countered by them amounts to acceptance has been settled in the case of Sairavanavuli. Has been settled by the Honorable Apex Court in the case of such and such. Apparently, the petitioner was terminated from service without giving a due notice as noted above, and her termination is in violation of natural justice, being illegal. Full stop. As such, the impugn order of termination of the petitioner issued by the authorities of Dingram MA School such and such, White number somewhere. Annexus 6 to this petition. With effect from 13/08/2001, 2011. Pursuant to the resolution adopted by it on 13/08/2011. Let's set aside in cost. Petitioner shall submit a certified copy of this order along with copy of her petition along with the annexes appended thereto. The copy of the affidavit in opposition submitted filed by the Inspector of Schools, the Mahasa of Long, and her reply to the affidavit of the said affidavit, her reply to the affidavit of the said response number 3 before the president of the school managing committee of such and such a school, right, as well as the head master / headmistress of the said school, forthwith obtain necessary acknowledgement in that regard. Needless to say, the authorities of such and such school may initiate a fresh departmental proceeding against the petitioner. Shall not be allowed relief if so wishes, but in accordance with law. All right. The above observation direction, this petition stands allowed to the extent above.
But their original records are- but their original records. Records are-
What records?
have provided.
Where is the original? This is a photostat copy. This is cannot be called the original. It look.
Order number 3.
Taken up on another day, my lord. Sir, K. Gogoi is held up in another court, my lord. Mr. K. Gogoi is election another court.
Why is it good? You were there?
He will argue the matter, my lord.
Huh?
He will argue the matter, my lord.
Why you will say, what is there? What is standing counsel?
May I please as a lordship? My lord, this is that matter, my lord. My lord, as per this affidavit filed by the higher education, my lord, their stand is that as I have not completed the 15 years of service, therefore, my lord, my post as a principal cannot be provincialized. Now, my lord, if the same yardstick is applied, my lord, in the entire state, my lord, who those services which were provincialized in the year 2011 Act, my lord, not a single person, my lord, who has been provincialized.
Do one thing.
My lord, my lord.
Have you made them parties?
No, my lord, I have not made them.
If you have not made this party, then you will not have any such negative equality.
No, my lord,
If somebody has been done illegally, then either you have to make them a parties
My lord,
and face the consequences on the basis of this particular affidavit of the Director of Higher Education,
my lord.
challenge their appointment, provincialization. We'll see.
Lord, many people will suffer, my lord.
Then decide either you will suffer or let them suffer. Two things will not go. Now, as you know,
My lord. My
the
lord, it is not a case of.
2011 Act,
My lord,
which has been
Stepped
declared
down.
as ultra virus,
my lord.
as well as the present Act of 2017 for provincialization.
My lord.
It is clear that a person at the time of his appointment must have the requisite eligibility.
Right.
And it is good for the purpose of higher education. It is the regulations issued by the UGC for the purpose of a principal of a college.
My lord.
Now, if it is 2010 regulation, or it is any regulation prior to that, because you are appointed, you joined on
My lord,
10th of December 2010.
2010.
And by that time, the 2010 regulation was already brought into force.
My lord.
And which requires that the candidate for the post of principal
My lord.
must have 15 years of service,
My lord.
must have 55% of marks in his master degree.
My lord.
If it is reserve category, then 5% less, that is 50.
My lord.
And if any of the such eligibility criteria
My lord.
is not there at a relevant point of time, then case of such persons cannot be considered for provincialization. Now, the 2017 Act
My lord. Lord, section 6 at page 115. My lord.
just a minute. Now, you want to get the benefit of 2017 Act
No, my lord, this petition is for.
for
2011.
2015, right?
My lord. My lord.
Okay.
Lord, under the 2017 also, my lord, they have carried out an exercise and they have said that as this writ petition is pending, so therefore that 2017 benefit can also not be given to me, my lord. Thereafter, several order has been passed by protecting the rights in this petition, directing the higher education department, my lord, to finalize my provincialization under the 2017 Act if I am eligible, my lord. That also they have not carried out, my lord. Now, this person from 2010, my lord, till date is discharging his duties, my lord, without any benefit, my lord.
Mr. Gogoi, you are appearing in the matter?
I'm sorry, Lordship, in the middle of a matter, Lordship. I am late.
Now, we have seen the petitioner was directly appointed as a principal of the college
Lordship,
during its cancer stage
Lordship,
without having any experience of serving as
Lordship,
assistant professor or associate professor or whatever,
Lordship,
right?
Lordship.
Though the particular regulation at the relevant point of time provides that must have 15 years, though the particular
Lordship,
regulation at the
Lordship.
relevant point of time provides that they must have 15
Lordship.
years of teaching experience,
Lordship,
right?
Lordship,
Now, the contention of the petitioner is that bypassing that provision,
Lordship,
almost in all such provincialized colleges,
Lordship,
provincialized under the 2011 Act as well as under 17 Act,
Lordship,
principals without having such experience have been made
Lordship.
principal of the venture colleges. Is it a fact? Whether petitioner has right or wrong, we are not saying.
Lordship.
Whether is it a fact?
Regarding that, Lordship, I have not know any knowledge regarding that aspect. Lordship.
No, petitioner said he has given the list.
Petitioner has given the list, Lordship, then petitioner made the party name, Lordship. If they are
Doesn't matter.
permanent, Lordship.
You are silent on that in the
Yes,
affidavit filed by the director of
See,
higher
we
education.
are basically on that, Lordship. He is not he has the not required qualification, Lordship. He has the not required qualification, and the read jurisdiction is on the principle of the positive, Lordship, concept of Article 14, Lordship.
No, but if the petitioner
Lordship,
succeeds,
whether, Lordship,
if the petitioner succeeds
Lordship,
before the court
Lordship,
to the extent of showing
Lordship,
that similarly placed persons have
Lordship.
been considered,
Lordship.
then court can definitely take in these matters into
Court can
consideration.
definitely
Not
take-
for his any right, but for something else.
Lordship.
What do you have to say against that? Is it, that is the reason we are asking you?
It's Lordship. I'm agree with Lordship. Lordship may take any action. If the authority has Lordship failed to do the things which should be done as per the statute and procedure, Lordship, then Lordship may pass any order, Lordship. I have no any objection. Lordship may record my statement also, Lordship. If the state officer do something in a particular way, Lordship, if we violated that particular way, Lordship, then Lordship may pass any order, Lordship. We cannot go beyond the Lordship, the law laid down by the attached court, Lordship. In this particular case, Lordship, basic
Just a minute.
Lordship. Regarding the annexer lordship, regarding in case of principal lordship, initial date of zoning, one annexer 48 lordship, 1993 lordship. 1993. Another person is lordship also 1995, next page 49 lordship. The regulation says that it should be the minimum required length of experience is 15 years lordship. Regarding the lordship experience part lordship, Honorable Apex Court even lordship interfered the appointment of honorable judges of this honorable court lordship. After issuance of warrant by the honorable president lordship, it was recalled. Your lack of the experience part of the honorable judges, which was lordship. So lordship experience part lordship, we cannot compromise lordship. And lordship, after the start down of 2011 Act lordship, probably lordship, the petitioner has no case under the 2011 Act lordship.
No, his name was again considered.
Again,
Government have
under,
issued notice.
under lordship 2017 Act, his name should be considered at best lordship. Under 2017 Act, it cannot be.
I think some documents which you've seen.
Even lordship, some notification is issued lordship in favor of him lordship. Then also he is not entitled in the light of the latest judgment of the Honorable Apex Court lordship, which is a
You might have the speaking-
judgment lordship is passed in 1st February 2022 lordship.
Hmm.
Regarding struck down Act lordship. If he judgment lordship. In lordship permit, I can press that judgment also.
Which judgment?
Lordship, it is Sujo Kumar Ukram judgment. It is came from the Manipur lordship regarding Assembly Secretary of the Manipur lordship. That
Hmm.
was lordship. That particular act was repealed lordship. Then it was came to the Honorable Apex Court. Honorable courts, after considering all the aspects lordship from the beginning Gopalakrishnan case to lordship till that lordship, discussing all the law laid down by Honorable Apex Court. Honorable Apex Court lordship finally that three judges bench has laid down the law lordship.
What?
Where it says that lordship, if lordship permit, I can read only two paragraph lordship.
Hmm.
Paragraph 18 lordship, where a statute is adjusted to be unconstitutional, is as it had never been lordship. Rights cannot be built up under it. Contracts which depend upon it for their consideration are void. It constitutes a protection to no one who has acted under it. No one can be punished for having refused obedience to be before that decision is made. Lordship, by observing one judgment from the Honorable Lordship Court of the America Lordship, then Honorable Court says that observe that an unconstitutional act is not law. It confers no right. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed, lordship.
Hmm.
Then lordship again, that all by considering the all the judgment, Honorable Apex Court in paragraph 23 has summarized, lordship.
Hmm.
Guluknath case also discussed in this case, lordship. The principles can be deduced from the law laid down by this court as referred as above are a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law, lordship. After declaration a statute as unconstitutional by a court of law,
It is non-est for all purposes, Lordship.
So action taken under that act is non-est.
Lordship, as per this judgment, if Lordship, there is a saving clause, Lordship, only the power under Article 146, Lordship. The Honorable Apex Court can, Lordship, let down the law. Even in respect of repeal act, Lordship, there, if there is a saving clause, then, Lordship, that will be there, Lordship. Even, Lordship, regarding repeal act also, Honorable Apex Court retracted that provision, Lordship. If a saving clause is there, Lordship, then it will be there, Lordship. The act which was attained finality, Lordship. Those act which attain finality, Lordship, that will be there in respect of there is a saving clause, Lordship. In respect of 2017 act, we have the saving clause, Lordship. Even, Lordship, if Lordship permit, I can place the Honorable Apex Court judgment in respect of the Lordship experience part, Lordship.
Do you have the 2010 regulation with you?
Lordship, I have.
Kindly provide.
Lordship,
Do you have the regulation?
I.
Now, just tell us when it was notified in the Gazette.
The Gazette notification, Lordship, in 30 June 2010, Lordship.
3006.
30/06/2010, Lordship. Before that, Lordship, 1998 UGC regulation is there, Lordship. Where is also it is stipulated that, Lordship, 15 years required experience, Lordship, experience part, Lordship.
Okay.
This is there, Lordship. From since
90, along with you have the 98 regulation.
98 regulation, today I am not being part, Lordship. I can place it by through where the judgment also, Lordship, that I have just delivered the binding, Lordship. That Rajanibala Agarwal case, Lordship, is there, Lordship. Paragraph 7 and 9, Lordship. 7 and 9, Lordship. If Lordship permit, I can read.
Just.
Lordship.
No, this after Rajanibala Agarwal doesn't say about the
Yep, 1998 part, that is not there, Lordship. Even, Lordship, in the page 87, internal page 87, this is a judgment from the Honorable Bombay High Court, Lordship, Goa Bench, Lordship. Here, Lordship, in respect of that, UGC regulation is discussed, Lordship. Page internal page 87, Lordship.
And in the 2010 regulation,
2010 regulation.
Ms. Saikia,
You have to attend for 9 and another 13. So 9 might not they other side want to take them. Mr. Bhattakur has gone to Delhi. And 13 also may not kindly fix some fees because I'm not here now.
21, we can give you time from the week commencing from 28. One is on 21st or 23rd.
21st or 23rd. And but hearing day, my lord.
No, those are hearing days. That's why it will be, otherwise we are taking up hearing matters on
21, yes, my lord, fine. 21, my lord.
21st,
21st, both the
both
matters.
9 and 13.
Yes, my 9 and 13.
And we have on, as agreed by the participants. But at the request of the parties, that we fix on 21st of February. Do that separate order koriba, date to etik koriba. Okay.
Oblige.
No, that is the notification, but when it was published in the Gazette of India,
Yes, that notification today, Lord, I have not received. Make it 16, 13. It's notified in the Gazette in 30 May itself, Lord.
30th of June itself.
Lordship.
We'll get it from the net.
Lordship.
No, in the earlier 1998 regulation, as we have noticed
Lordship.
from that judgment of the Mumbai High Court,
Lordship.
there it appears that it was 10 years.
Lordship.
That was in 1998 regulation. But in 2010 regulation,
2010 years,
it
15
has
years.
been made as 15 years.
15 years. Yes. When Lordship in the compilation Lordship, my Lord may produce page 6 Lordship, compilation 6. Which is one of the most important honorable apex court. That particular judgment was also placed today morning in respect of the appointment of the Madras High Court judges Lordship for the honorable court Lordship. An honorable court observation that I have just go through it Lordship through live logit. Honorable court distinguished the judgment that honorable court says that experience, part and suitability is a defined thing Lordship. The particular honorable judges whose appointment was challenged.
Yes, in the
before
case
today
of that
regarding
Kumar Padma Prasad, that
Kumar Padma
particular
regarding experience part.
recommendation.
Regarding expense part Lordship.
The
That particular judgment was also placed before the honorable apex court today. Today
No,
just that
that's what
discussion of
we're
the
telling you.
courtroom I have seen.
That was a case
Lordship.
where for recommendation, he must have 10 years of practice.
Lordship.
And though that president notification was issued, the
Lordship.
warrant of appointment was issued, but the
Lordship.
concerned incumbent didn't have 10 years of
Lordship.
experience.
Experience. That way
Accordingly,
you should
the
recall,
court
Lordship.
intervened and the honorable apex court has also intervened to that extent.
Lordship.
So that experience part,
Experience
the
part
court did
Lordship
not interfere.
did not
But in
interfere.
the case of the Madras High Court,
Madras
the
Lordship,
recommendation,
the suitability part. Honorable court says that suitability and expense are two defined things. So honorable court dismissed the SLP preferred by the learned two advocates Lordship. That judgment was placed before the honorable court today also. And it was Lordship all in live law article, it was Lordship given.
because it was that Madras bar
Lordship.
opposed against
Madras
that
bar
recommendation.
basically Lordship, not only Madras, not Madras bar basically Lordship. Some of the advocates of the Madras bar.
Madras, some
Lord,
people,
some-
that's why
some people.
they objected that recommendation
Lordship.
of the collegium, right?
Lordship.
Yes, Mr. Bhuyan.
If Lordship then
My lord, if we take up the 2010 regulation, which was operating at the time of appointment of the principal, appointment of the present petitioner as well as the yardstick which they have followed for the purpose of provincialization of the entire set of principles in these provincialized colleges, my lord.
One thing
Milo.
from the
Milo.
this particular petition, you
Milo.
have mentioned one thing, and that's what
My lord.
I was reading it in the morning. Please come to para 3 of your
My lord.
page 5 of the read petition.
Yes, my lord, that the governing body of so-and-so college Tezpur published an advertisement for the purpose of filling up of the vacant post of principal.
Where is that advertisement?
My lord.
Where it was issued?
Uh, That advertisement I have not annexed, my lord. And the, my lord, it was a venture, purely a venture institution. my lord.
See,
My lord,
you will be aware of that judgment.
my lord,
Honorable Justice Biswas as you was then.
my lord,
Similar nature, advertisement was issued.
my lord.
The earlier it was in the notifications is in the university system. The appointment
My lord,
was to be carried out in the university system.
my lord,
Now, that was a post for principal and other posts are for assistant professors and all. That was lecturer at that point of time because it designated. Now, the university system, in that case, UGC was not a party, so the court insisted to have the UGC a party. And there will be a decision of around 2000. Or maybe 2001 to somewhere that part, Justice Biswas passed. It's not reported probably. That university system has been clarified by the UGC, where the court observed for any such affiliated college of the university,
my lord.
These higher educational institutions must follow the system as accepted by the university.
My lord.
And in that case, the university clarified that university system is that adoption of the UGC regulations
My lord.
adopted by the university. That's why each college have their own, like the rules, because you see the colleges are affiliated to a particular university and university might have adopt some different rules of their own selection and process. So that is why at that point of time, pursuant to the observation of the UGC, the advertisement is to go with the university system. Now they are specifying the regulations.
My lord.
Now, earlier it was university system. And in that circumstances, this court,
My lord.
made by Honorable Justice Biswas as he was then, have clarified this issue. So this particular college, either affiliated to Tezpur University or Guwahati University or maybe Dibrugarh University,
They have a system, my lord.
they will have a system.
My lord.
And for the affiliated college, the lecturers or whatever the persons appointed under the system, there has to be appointed by under particular regulation of the UGC. That you need to clarify.
My lord, as a my lord, as a counsel, my lord, as an officer of the court, I will never insist, my lord, that an underqualified person should be made a principal of such a series. This is a very huge infrastructure, my lord, and the Tezpur everybody knows. And this person, my lord, is very diligently, my lord, is working as a principal.
See,
My lord.
basically difficulties you see, a person
My lord.
without having any teaching experience,
Yes, my lord. Yes, my lord. Directly, my
how
lord.
can be made a principal?
My lord.
This person have no experience at all in the
No,
teaching.
no, my lord.
He is qualified.
He's a direct entry as a principal. my lord.
That cannot.
I can
Why?
understand. my lord.
That's why the particular, now the notification long back,
My lord.
sometimes in 2005 itself or 6 itself, it has clarified that while acquiring MPhil, PhD, that particular period cannot be considered for the purpose of teaching experience.
Yes, sir. Yes. Because he's out of the service, my lord. That's
So
it.
for that purpose, we are saying that unless having a teaching experience of 15 years in terms of 2010 regulation,
Exactly, my lord.
how can a person can be considered to be opposed to the post of professor?
My lord, from my limited understanding, my lord, exactly similar analogy also applies, my lord, to the person, my lord, who has been made the principal of provincialized colleges. My lord. Why I am submitting, my lord, if my lordship maybe may get trouble to go through the, my lord,
That's
regulation
what
of
we are telling.
2010. my
If you
lord.
are aggrieved,
My
if you are aggrieved with certain facts that the,
My lord.
in similar circumstances, some of the persons serving as principal in such Spencer education institutions whose
my lord.
services has been provincialized
My lord.
without having the requisite eligibility
Eligibility
of
as per
15 years
regulation, my lord.
of specified by the 2010 regulation.
My lord.
You give the names, we'll see.
My lord, I will furnish the entire list, my lord, on the next day. my lord.
We'll see.
Yes, my lord.
Because I still remember Mr. Ramsekya has filed a case.
My lord.
He has given a list of principals serving in different provincialized colleges,
My lord.
obtaining their PhD degree
From outside the state.
from the universities
My lord.
in the
Outside.
distant education
My
mode.
lord. Verification has been done by them, my lord.
And they are silent. Mr. Gogoi will feel shy to say that. But
My lord.
the reputed college,
My lord.
Guwahati,
Yes, yes. Having that principle, I know, my lord, I know.
right?
My lord.
So maybe they are blue-eyed boys, so the authorities are not taking action against them.
My lord,
But-
it is admittedly, my lord, I cannot claim a negative equality also, my lord, but they can, my lord.
Bring it
My
to the notice, we'll see. Mr. Gogoi has very definitely said that if it is a fact, then definitely those.
Proceed,
will be
proceed,
considered.
proceed. Then also,
Because
my
no
lord,
one
may-
is above law. He admitted that fact. We'll see.
I will furnish the list by of an additional affidavit.
Not Mr. Yavunia, London Council for the petition, and Mr. K. Gogoi, Standing Council Higher Education at length. Petitioner submitted. Petitioner admitted to the fact that though he is PhD and he obtained a PhD.
Lord, I have obtained the PhD, my lord.
In the year 2006
My lord.
and also qualified NET conducted by the UGC in the year 2000, in June 2005. But in spite of his appointment as a principal of Lokopriya Gopinath Bodoli Girls College, Keteki Heritage School, during its Spencer stage, the respondent authorities on 10/12/2010, the respondent authorities did not consider him this case for provincialization. Stating that he doesn't have the requisite teaching experience as notified by the UGC regulations. In that aspect, Mr. Bhuya submitted that the respondent authorities have provincialized numbers of such service of number of such provincial numbers of such principals numbers of principals serving in different venture education institutions in the state who didn't had the requisite teaching experience notified by the UGC. And for that, he prays for some time to give the entire list. And please sometime, allow him some time to submit the detailed list of such principals. Service has been provincialized without having the requisite teaching experience. List on 23rd.
Yes.
Mr. Das, Mr. Gugoi is keeping certain materials with him, which are very much essential for the court to consider the matters.
I am
At least
always,
being along with him, try to have those things with him.
I am always to keep it. I am
We don't know, will not say beyond that.
Just one paragraph I needed to place before your lordship. That, my lord, Billu Bora Soikia, the case law already I have given.
Hmm.
Four legal principles were enunciated in that judgment.
Same as Pawan Pratap.
Before Pawan Pratap, paragraph 23, if your lordship kindly takes for one moment, my lord.
Hmm.
Paragraph 23.
Yes.
May I just read out, my lord?
This is from paragraph 45 of the Pawan Pratap.
Correct, my lord, correct. And just if your lordship kindly turns to the next page, clause 2. May I just read out the clause 2, my lord? Inter se seniority in a particular service has to be determined as per the service rules. The date of entry in a particular service or the date of substantive appointment is the safest criteria. So, my lord, in my case, as your lordship had seen, my lord, I was regularly appointed on 30/10/1998. That was my date of substantive appointment. Whereas the date of substantive appointment of the petitioner is 11/6/1999. So on this count, my lord, I still a march as per Pawan Pratap, as followed by this honorable court. And secondly, my lord, it says the next clause, ordinarily notional seniority may not be granted from the back date. And if done, it must be based on objective considerations and on valid classification and must be traceable to the statutory rules. Now, if your lordship, my lord, allows the petition of the petitioner, my lord, that would be amounting to giving him notional seniority over me, my lord. Because admittedly, his date of substantive appointment was, my lord, 10/6/1999. And he cannot be given a notional seniority, my lord, because in the meantime, I had been validly regularized. If your lordship kindly takes that, my lord, paragraph 23, clause 2, clause 3, I have already read out.
Yes.
And clause 3, clause 2 and 3 I have already touched, and clause 4, my lord. Clause 4 says, my lord, same from Pawan Pratap. It says the seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressly provided by the relevant service rules. Now, in this case, there is no service rules which says that retrospective seniority can be given unless it is so, because seniority cannot be given on retrospective basis when an employee has not even been born into the cadre. And by doing so, it may adversely affect the employees who have been appointed validly in the meantime. Two, 3, and 4 of Pawan Pratap. So on all these counts, my lord, because the entire claim of the petitioner before your lordship is the fact that he admits that he was regularized subsequent to my regularization. He admits that he was regularized on 10/6/1999, which is almost after a year of my regularization. His only claim before your lordship, my lord, is that he was regularized with effect from the date of joining, and therefore he should be given seniority over me. That is his only claim before your lordship. And if we apply all these legal principles, which were enunciated by it's all settled, my lord, as has rightly fallen from your lordship prior to the recess, Pawan Pratap makes it clear.
Okay.
My lord, I have been
There is an Assamese proverb.
My lord,
Are you
I have-
aware that Kole hingi khahe? Are you aware?
my lord, I've heard.
You have heard. There is also proverb in Hindi that in that net, how many holes? You have so many holes. The other small net is laughing at the bigger net, because that is an issue probably in the Hindu system, the wives are looking at the moon in the evening, in the Karwa Chat, right? And that certain issues that they cropped up, that the small net was laughing at the bigger net that how many holes you have in your. So here you see both the entry of the writ petitioner as well as the entry of the private respondent are not in conformity with the law.
Correct.
But since
Correct.
nobody is raising any issue with regard to
Correct.
their regularization or whatever
Correct.
consideration, nor by the respondent authorities.
Correct.
And we leave it to those appointments to be not deciding on those issues. But we leave it to the state authorities. We are not going to decide because on what aspect who has been considered. But we have found that the inspector of schools affidavit not very satisfactory, and a kind of officer of that kind not to be accepted.
That is correct. In this regard, my lord,
Not inspector of schools, some new report has come
in,
where that appointment of the petitioner has been said to be
yes,
valid, and
because my lord, only thing I want to
his
point out.
seniority should be considered from as he was appointed against sanction post.
That affidavit has no
So
meaning.
we are nothing nowhere, but we'll make it
That
clear.
affidavit has
So
no meaning in light of
We'll
the,
remand the matter back to the respondent authorities.
but for my lord, in my humble submission, my
They
lord,
will decide the seniority between the petitioner and the respondent.
in my humble
And
submission,
till
my lord,
that, if any selection has been made for the post of headmaster of ME schools in the district of Karimganj, and that too without publishing any gradation list, we leave it to the authorities.
because this is only an in-charge post, my lord. This is not a regular
That's
selection.
true. That determines the seniority, right? Once the seniority issue is there, that will also have the issue
No,
in the
that is why, my
regular.
lord, that is why I pointed out in the morning at the starting itself, at the start of my argument, that an additional affidavit was filed by the petitioners, a copy which was given to me only on the last Friday. Now, I needed some instruction with regard to this affidavit because they have annexed.
Or we
Only
can do
annex
it,
Select list, nothing else.
Because
Mr. Fukan, instead of passing the order today, we can pass the order day after tomorrow. But tomorrow, day after tomorrow, you have to tell us on the basis of this selection as to when the constituted selection committee published the gradation list of teachers with regard to ME, MB and ME madrasas separately for this district. Because the guidelines placed by Mr. Sisti is very clear.
Koriamganj.
Do you have a copy of that communication? You don't have, okay. Read the 1 to 8. বড়ুয়া, download করে তাকে করে দিবে। Download করে ঠুছে। Now read it, Mr. Fukan, you read it.
Yes, sir.
This is the prevailing one, right?
Yes, sir. The previous one has been listing and now it's
It was already there, now just modified something,
Modified.
we'll see to that.
in suppression of the this department's earlier notification dated so and so. Dated so and so, the governor of Assam is pleased to frame the following procedures for promotion to the post of headmasters and
Mr.
headmistress
Udin, take your seat.
of ME school, MEM and MV government provincialized MV schools and government senior basic schools. The post of headmaster, headmistress of above mentioned schools shall be promotional post. Appointment to the post shall be made on the basis of seniority cum efficiency and recommendation of the DLSC to be constituted by the director of elementary education. And then, my lordships, point number 2, the committee shall prepare a district gradation list of teachers separately for MEM, MV, provincialized MV schools and government senior basic school. In order of seniority, showing date of appointment, education qualification, year of passing of training, age on the date of appointment, date of retirement, which should be communicated to the incumbents with copies to all the concerned authorities for information. Next, your lordships, point number 3, selection for the post of headmasters in such schools shall be made strictly on the basis of seniority cum efficiency. And also, fourth point, lordship, the teachers having less than 10 years of continuous services shall not be considered for promotion. That 5, teachers who have passed at least metric, HSLC, normal, or have at least intermediate or its equivalent qualification or above have successfully undergone necessary training as may be prescribed by the department shall only be considered for promotion. However, the teacher who have completed minimum 15 years of continuous service but no facilities have been provided to him or her for the present training may also be considered for promotion, provided that there is nothing adverse against them. 6 is the committee shall prepare a panel of selected teachers which shall remain valid for 1 year from the date of selection. 7th is in case of a Hindi, classical or language teachers having required minimum educational qualification and training may also be considered for promotion. The committee shall follow the Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancy in Service of Posts Act 78 and rules as amended framed thereunder, preparation of panel of teachers for post of headmaster, headmistress of ME, MVM, MV government and provincialized and government senior basic school.
So read 2
The committee
and
shall
3.
2 and 3. The committee shall prepare a district gradation list of teachers. So separately ME, MV, MEM for all the other schools. And then in order of seniority, showing date of appointment, educational qualification, year of passing, of training, age on the date of appointment, and date of retirement, which should be communicated to the incumbents with copies to all the concerned authorities for information. And
Communicated to
all the incumbents.
incumbents.
Has to be communicated.
Now 3.
3, my lord, selection for the post of headmasters in such schools shall be made strictly on the basis of seniority cum efficiency.
Now 7.
And your lordship, in case of Hindi, classical language teachers having required minimum educational qualification and training may also be considered for promotion.
Now see the difference. Teachers who have passed at least metric HSLC for 15 years, right?
My lord.
But here with regard to the language teacher, including Hindi and Assamese,
Correct.
because it says Hindi, classical and language teachers. It is the required minimum educational qualification
My lord.
and training. Here, the training part hasn't been not discarded. Training has been discarded for those persons specified at 5. Secondly, here at 7 it said may also be considered. It did not say that shall.
May also be not necessary.
Both the petitioner and the respondents are language teachers, either Hindi or Assamese. Now, how do you have the efficiency? How do you determine the efficiency? You have given this notification, fine. Where is that efficiency? Gradation list on the basis of their date of joining, on the basis of seniority, date of appointment, educational qualification, fine. Where is that efficiency part?
How to determine?
What is that efficiency? Those who can give highest to the committee has the efficiency or something special? Mr. Sisti, is there any other notification by the government in the education department? How to determine this efficiency? Nothing as on date, nothing has been placed. On what basis the committee then decides?
How to measure efficiency?
The things are always half done. That is the difficulty on the part of the respondent authorities. When you do something, do it fully. Okay. On Thursday, you tell us, Mr. Fukan,
My lord,
when this gradation list was published
my lord.
and was communicated to the incumbents of Karimganj district. Right?
My lord.
Number one.
Number one. And my lord, that other notification also, Lordship had mentioned
What is the efficiency?
efficiency part. And, how to determine.
The efficiency. Secondly, since this is of last year, selection was of September, whether the Director of Elementary Education Assam have approved the list or not. Because earlier, that notification 2010, there it was very specific. The committee that select list prepared needs to be approved by the Director of Elementary Education Assam was not there in any of the provision. But the record reveals that you will see from the judgment of Justice A.K. Goswami, where the selection was held, headmaster selections in different districts. And subsequent to that and prior to that also, all these lists are approved by the director. So since selection was held in September 2022, the communication also shows there is a requirement of SCRs of those selected for onward communication to the director. So the Director of Elementary Education has approved that select list considered by the committee. Give us these informations on Thursday.
Four information. Four.
Yes. List on already. Hardin Patwika. List on such. Enabling Mr. A. Fukan, Standing Council Elementary, to place the 11 instructions in the matter with regard to the select list of headmasters of provincialized and government basic MEME and ME Madrasa headmaster, headmaster superintendent, the district of Karimganj, selected by the committee on 14/7/2022, annexed by the petitioner in his additional letter. All right.
All right.
Yes.
It speaks for today for disposal.
The matter about.
Matter regarding appointment of professor, assistant professor in Kasar College. So that matter, my lord, where we are selected, but since we are from outside, our appointment has not been issued to us. Higher education. That matter, my lord.
In this case, we will file if otherwise law is well settled. Recently, Honorable Supreme Court Chief Justice Ben judgment is there. We cannot discriminate.
regarding place of birth. and
No,
place of
that,
residence.
see, only thing was that in the notification for selection issued by the authority,
No, sir.
must have proficiency in the local language,
No, sir.
right?
No, sir.
The name of the petitioners were recommended to the Director of Higher Education
No,
for
sir.
appointment.
No, sir.
And it was pointed out that these persons are from outside
No, sir.
the state of Assam. Then Secretariat wrote to the director,
No, sir.
right?
No, sir. No, sir.
Because Mr. Das probably
We're
placed
giving
that
some
record.
Yes.
And that record clearly indicates there is nothing. It was pointed out, these are from the outside.
No, sir.
But basically, the petitioner, since the matter pertains to a college in the Morak Valley,
No, sir.
she has Bengali.
No,
The
sir.
post is Bengali.
No, sir.
She a lecturer of Bengali.
No, sir.
She has qualified in Bengali.
No, sir.
What's wrong in it?
No, sir. There is nothing wrong.
He is in the-
Lordship may finally dispose of the matter next day by relying the attached letters. I will place the judgment, Lordship. Lordship, I will place that. Lordship. That 2001 itself, attached to reiterated in 2022 also, Lordship. I will place. Lordship may dispose of in the next day.
Give us the date.
Lordship.
Give us a date.
Lordship, we commencing on Form 20, Lordship.
Hardin Park,
Lordship.
placed on 21st.
Lordship.
Enabling Mr. K go to place the relevant
Lordship.
instruction as well as the judgments of the honorable effect, judgments in this regard.
Lordship.
21st February.
Item number 17, my lord. Then item
Yes, item number,
regarding date of correction, 17, my lord.
what's the matter about, ma'am?
Matter is regarding correction of date of birth, my lord. Because of pendency of this matter, my lord, the petitioner is
Okay.
neither receiving salary nor pension, my lord, because his date of birth is under dispute.
17. Which department?
My lord, it is the SEBA, my lord. The
Yeah,
petition
he is
is
Seva
done by
again.
the SEBA.
Basically, they are given is against Seva Lordship.
Just. বড়ুয়া লিস্টখনো সোমাই বললে কি দিছো তো? নাই কোনবাটা হেৰি সোমাই গৈছে কোনবাটা ফাইলত সোমাইছে এই আগৰ ফাইলটোতে সোমাইছে হুম
District. What is your submission?
My lord, my submission is that, my lord, for a date of birth, the most often authentic document is the school admission register, my lord. And as per the school admission register, the petitioner's date of birth is 1/7/1962. That is, your lordship may kindly turn to page 39, my lord. This is an extract of the school register. On 18/1/1971, my lord, his age was 8 years, 6 months, 17 days, my lord. If you calculate it, my lord, his date of birth will be 1/7/1962, my lord. And in page 44 also, my lord, the headmaster himself has admitted, my lord, page 44, my lord, as per the admission register of the school, his age on 18/1/1971, date of admission, has been observed as 8 years, 6 months, 17 days. This is for information. So, my lord, the principal himself has admitted, my lord, and this is the most authentic document, my lord. Later on, there may be several, my lord, mistakes or corrections, my lord, but this is the only, my lord, record on the basis of which his age may be considered, my lord.
We'll take up this on Thursday
Yes, my
as
lord.
a first item. You are appearing for whom?
Next one, number 6. Headmaster. Well, item number 18, my lord, I'm praying for a fixed date, my lord. Here is a case, my lord, where 2 students were expelled from the college, my lord. They were rusticated. My lord, today, I have seen the office note of 6/2/2023, my lord. Service is complete. They have appeared for the private respondents, my lord. May I pray for a fixed date? Because, my lord, the next,
File.
they have already missed the 5th SEM exam, my lord. The 6th SEM exam are commencing from the month of May.
You are appearing for someone?
3 and 4 years.
What's your good name?
P.A. Chaudhary. P.A. Chaudhary.
T for Tamil Nadu.
Yes.
You can also represent 5, 3, 4, 5. Because governing body of the same college, you are appearing for the college. The college is represented by 5.
Yes. But president is a separate person.
Hmm?
The governing body president is selected. Not the
See, this
principal.
particular college, president will have specific term, he will come and go. The response number 3 is the college.
Yes.
College is, the principal has been separately made a party. The college is represented by the principal. So you are not appearing for the 5. Doesn't matter. Principal is the member secretary.
Yes.
And 5 has received notice. Who is appearing for 6? Okay. Heard Mr. M.R. Odhikari, counsel for the petition. Mr. K. Gogo is standing counsel higher education for the respondent numbers 1 and 2. also heard Mr. P. A. Chaudhary, Learned Counsel, presented appearance on behalf of the respondent number 3 and 4 by filing of Alaknama, whose name has also been reflected in the cause list. It is seen from the office note dated 06/02/3 that notice has been duly served on the respondent number 5 by registrar post delivered on 10/12/2022. However, the respondent number 5 has not, in spite of receipt of notice, did not appear in the matter. Respondent number 6, the respondent Guwahati University. Respondent number 6 is Guwahati University. As a service is complete on all the respondents. This is the matter for admission. 22nd.
In the meantime, my lord, if they choose, my lord, they may file the affidavit, my lord. Because again, on the next date, my lord, they will come up and say, my lord, they will pay for time.
I won't do it pending. Look at the second page video. The respondent numbers 3 and 4. Self-file affidavits. Self-file its affidavit in the matter on or before 17th of February. Self-file its affidavit, likha, if so advised, on or before 17th February without fail. Serving a copy of the same with the counsel for the petitioner and other respondents.
Can it be in 27th?
It should be delayed.
So some record will be required from the college.
You get it? It was a big deal. It's in Hojai. How many hours journey to Hojai? Had it been Hailakandi, Karimganj, we have considered. Don't sit time just simply like this.
May I please your lordship? May I please your lordship?